Great. So Linda Goldstein has offered to give us a presentation on the top 5 legal and regulatory risks here for the digital marketing and the Digital Council. So would you like to start giving your presentation, Linda?
Yeah. Hi, everybody, and thanks for joining. So what I'm going to try to do very quickly is cover 5 of, I'll call them the top legal and regulatory risks. There are obviously lots more, but I think probably in terms of what we're seeing with enforcement and companies getting into trouble, these are probably the top 5. Some of them remain risks in traditional marketing as well, but I think in some cases the risks become heightened because of the challenges of digital media in terms of space constraints and some of the platform limitations. So let me just get right into it. Probably number 1 on the list, which is compliance with the FTC's testimonial and endorsement guides. And I think, as many of you know, in 2010, the FTC amended the testimonial guidelines specifically to address what was happening in digital media and in social media, and for our industry where testimonials are such a critical part of our marketing. That's created a heightened risk in the digital space. 3 key provisions that the FTC reinforced when it amended these guides back in 2010 are that any material connection between an endorser and an advertiser has to be disclosed. Secondly, that we as advertisers actually have the responsibility for ensuring that the disclosures are made. So even if influencers or bloggers that we retain, even if we don't have control over their content, we are nonetheless responsible for making sure, if they're advocating on our behalf, that they're making disclosures. And the third one, which we sometimes don't think about, is that we're also responsible for any of the product claims that are made by an endorser, again, whether in traditional media or in social media, but there's so much less control in the social media space that it makes it a little bit more challenging. What's happened since 2010, which to me has elevated this to probably one of the biggest risks in digital media, are 3 things. The FTC's views have become much more restrictive in terms of what actually is an endorsement, what is a material connection, and what is adequate disclosure. And let me just briefly kind of take you through the journey of what's happened. So this trend really began a couple of years ago when the FTC brought an investigation against Ann Taylor. Ann Taylor had run sort of one of their typical runway shows. They invited fashion bloggers to come to the show as good hosts. They gave them goodie bags with inside was a $50 gift card that you could use at Ann Taylor. And then the bloggers went on and said, the clothes were great, great fashion show, whatever. They didn't disclose that they had received this little goodie bag, and the FTC actually opened an investigation against Ann Taylor, basically saying it was Ann Taylor's responsibility to tell these bloggers that they had an obligation to disclose that they had received this whopping $50 gift card and goodie bag. They didn't take any formal enforcement action against them. They issued what's called a closing letter, but basically said in there that it was Ann Taylor's responsibility to make sure that these disclosures were made, not only by informing the bloggers, but actually by monitoring what the bloggers were posting to make sure those disclosures were there. Then the FTC brought a series of very similar cases. I won't go through them. The story basically the same, bloggers receiving very nominal gifts from companies like Hyundai, and recently there was another one with Sony relating to its game consoles. And the story was pretty much the same, bloggers getting very nominal gifts and FTC saying that the advertisers were responsible for making sure that the bloggers made the necessary disclosures. Where I think the FTC, kind of went even above and beyond is a recent case that they brought against Haan. And in this one, which is up on the screen, Haan actually ran a sweepstakes where you could win a $1,000 shopping spree. Consumers were asked to simply pin images of Haan shoes and images of places they would like to travel, because the name of the promotion was The Wandering Soul. And what the FTC said here, believe it or not, was that the mere act of pinning images of an advertiser's product constitutes an endorsement, that at simply getting a sweepstakes entry, again, no value here, just a chance to win a prize in exchange for pinning these images in order to enter the promotion, was a material connection, that Haan should have instructed the consumers to properly label their pins. And even though Haan used the hashtag Wandering Soul as the hashtag for the promotion, the FTC said that wasn't sufficient to disclose that there was a material connection between the consumers who were entering the promotion and Haan. And so what do we kind of take away from that? Number one, this, sort of series of cases over the last several months tells us that compliance with these guides is a top priority. And I think that's important because historically in our traditional infomercials, these guidelines have been around for years. People have taken lots of liberties with compliance with the testimonial guidelines, and we haven't historically seen it come up in FTC cases in traditional media, but it is a top priority, and the FTC seems to be looking for cases in digital and social media to sort of make examples of companies. The second thing that jumps out is that even the simplest social media tasks could be viewed as an endorsement. So we typically think of an endorsement as somebody comes on TV and says, why the product works and why they like the product. And what's coming out of these cases is that the simplest tasks, a tweet, a post, a product review, simply pinning a picture of your product could be considered by the FTC to be an endorsement, and that any material connection between the advertiser, any incentive, no matter how nominal it is, could be considered material. So obviously providing free product samples is a material connection. So when we provide product samples to people who may be giving an endorsement, that's going to be considered a material connection. Things as simple as, a sweepstakes entry or even another free gift could be considered an incentive that would trigger these disclosure requirements. We as the marketers are responsible for making sure the disclosures are made, and the marketers are responsible for any product claims that the endorsers make. So the FTC, I think many of you on the phone know this, has brought cases involving social media campaigns for acai berry, for green coffee. And again, a part of these cases was, one, the failure to disclose the connections, but secondly, that many of the endorsers were making claims for these products that the FTC didn't believe could be substantiated. So I think the key point here is obviously, one, just be aware that in the digital space, this is a real priority for the FTC. And so if you're going to embark on any kind of social media campaigns around your products, it's really important to have a social media policy in place to make sure you know what the influencers are doing. If you're hiring agencies or vendors to conduct these campaigns, it's important to make sure you know how they're getting their influencers. Are they compensating them? How are they making sure the disclosures are being made? Because the FTC is definitely watching this one. The second thing I want to talk about has to do with ROSCA, which is the Restore Online Shoppers Confidence Act. And again, some of you may remember this is was a statute passed by Congress in 2010. At the time, it was, most people thought it was primarily targeted at the then very common practice of data pass in upsell situations where data was passing from one primary marketer to a secondary marketer in an upsell. But there was one provision in ROSCA that was not limited to, sort of upsells or post-transaction marketing, but apply to any negative option offer presented online. So that would include most DR offers, free trials, continuity, automatic renewals, any kind of a subscription program. And there are two key requirements under ROSCA. The first is that all material terms and conditions of the negative option offer have to be clearly and conspicuously disclosed, and they have to be disclosed before the seller obtains the consumer's billing information. And the second requirement is that the seller has to obtain the consumer's express affirmative consent to the negative option offer. So what's happened here since January of 2015, this has also been, actually I would say since late 2014, a top FTC priority. The FTC has brought 4 cases in rapid succession, and what is coming out of these cases is a clear indication that how the FTC is interpreting these ROSCA requirements is very restrictive, and they're kind of putting their own gloss on these requirements. And this really will come into play in your checkout process in 2 primary areas. The first is, what is the FTC considering clear and conspicuous disclosure? Not in the main text, not a disclosure by means of a hyperlink or a rollover. To the extent that you have any type of a negative option, whether it's a free trial or a continuity, the FTC wants to see the material terms of that negative option disclosed in the main text. And they're really going to want to see it pretty much adjacent to wherever it is that the consumer is providing their consent to the offer. And the second area where the FTC is really adding its own gloss is, what are they looking for as evidence of express affirmative consent? And if you look at some of the consent decrees that have come out, or the recent case against DirecTV, which we happen to be involved in, it's clear that the FTC is looking for something more than the consumer simply checking a box saying, sign me up or, submit offer. If there's a negative option involved, they're looking for some evidence of affirmative consent that relates directly to that negative option. So most of the consent decrees that have been entered into so far have actually required a checkbox or a similar mechanism where the consumer is consenting specifically to the negative option feature of the offer. And the third thing is, when is the billing information deemed to be obtained by the seller? And one would logically say, and there's merit to the argument, that the seller isn't actually obtaining the information, the billing information, until the consumer hits the submit button. But I will tell you, in conversations with FTC in some of these enforcement proceedings, it is definitely their view that what this means is that the disclosures should be made before the consumer enters their billing information, and that it's not enough to do it simply before the consumer hits the submit button. So again, I think it's important, and I would certainly encourage marketers to take a look at the checkout process, given the FTC's really heavy focus right now on ROSCA. So number 3 has to do with, making, and it kind of follows from ROSCA, but it's broader, which is making effective disclosures in the digital space. And let me just play this little clip for you, which I think tees up the issue.
In today's extended media minute, the Federal Trade Commission wants to impose old-world advertising restrictions on the free-for-all of Twitter and Facebook. But will that hinder this new medium and end up gagging advertisers? We're joined by the Director of Consumer Watchdog's Privacy Project, John Simpson. Thanks for being with us, John. I was looking through this 53-page report from the FTC where it goes into loving detail, dictating to advertisers or suggesting what they ought to do to make sure they disclose their tweets. And yet it even says, in fact, we've got a full screen on pulling the plug on Twitter, that if a particular platform does not provide an opportunity to make clear and conspicuous disclosures, should not be used.
Okay, so what they're referring to here are the FTC's .com disclosures. And again, when the FTC came out with the .com disclosures, we kind of hoped in the industry that the FTC would recognize that because digital media has limited space, limited real estate, it may be more difficult to make the disclosures, for example, in a tweet, even in a post or a search engine result, and that perhaps there would be some relief from that. But in fact, the FTC's position has been exactly the opposite, which is their view is if you can't make the disclosure in a medium or a format that has limited real estate, then perhaps you shouldn't make that offer at all. And that was kind of one of the key themes of the .com disclosure guidelines. Some others I want to highlight, and these are trends we're seeing in terms of the FTC's views of disclosures, both in general but particularly in digital media. They want to see the disclosures presented as close as possible to the triggering claim. Again, actually, if you look at the DirecTV complaint that was just issued, you'll see in the complaint and in the description of some of the practices that the FTC objected to, they're looking for disclosure on promotional pricing to be immediately adjacent to where the price is given, and we're seeing that just as a trend that certainly disclosures down the bottom in mouse type aren't going to hold true, and the FTC is looking for those disclosures to be as close as possible to whatever claim is triggering the need for the disclosure. They're assuming that consumers don't read an entire ad or web page, and they'll particularly look at colors and elements on the web page to see where the consumer's eye is likely to be. They don't like large or dense paragraphs. They prefer that there be layered disclosures, and that again sort of ties into what I said about ROSCA. So, for example, if you have a negative option, they want to see those disclosures separate. They don't want to see a big paragraph that has all the offer terms and conditions. It's also important to remember that the ads will be viewed on screens of different sizes, and they have to be readable, no matter what the browser, and certainly now with mobile, they have to be viewable on mobile devices as well. And what's important in the digital context is the FTC's notion that the disclosures have to be unavoidable, and what they mean by that is you really can't use hyperlinks, you can't use rollovers, you can't use pop-ups because consumers can block those pop-ups. It's got to be in a format where the consumer absolutely has to see it. And on the point of hyperlinks, the FTC has taken a much more restrictive view of hyperlinks as well, and have said it can't be used for any cost or safety information, so pricing information, in their view, could never be made via a hyperlink. And they also are very focused on what is the language accompanying the hyperlink. So one of the things they've said is they don't like generic labels, which is typically what we do, see detail, see offer terms. Their view is that if you're going to do something with a hyperlink, you need to more precisely label that hyperlink to let the consumer know exactly what the nature of the information is that's being disclosed. So if it were details on a refund offer or a guarantee or something like that, you wouldn't just say see terms, but you would see terms of our guarantee or something like that. Also on disclosures, there's been a shift in timing. It used to be that the standard was you could, as long as you disclosed all the material terms before the consumer checked out, that was sufficient. But what we've seen recently in FTC enforcement as well is they're looking for the disclosures early on in the process. So, for example, if you've got a free trial and you just talk about the free trial on the landing page and then don't really give the details of the free trial until maybe the checkout page or right before the checkout page, the FTC is likely to say that's too late because until the consumer got there, they may have had the impression that this was just free. And then finally, there is in the guidelines an obligation to make sure all web pages are optimized for mobile viewing. So just to show you some examples of what the FTC considered good disclosure or not good disclosure. This is one that was that they had as an example in their report. It was for a home security plan, and what's circled on the left is disclosures relating to the pricing plan. There were monthly prices, and then there were additional costs associated with the plan. It was to the left of where the actual price was, and the FTC's concern here is that on a desktop you might see that, but on a mobile device you don't typically scroll to the left, so that disclosure would likely have been missed, so the disclosure was not adequate because it was likely not to be seen on a mobile device. The second one is an example of labeling of hyperlinks. So in this particular case, below the price, there's a hyperlink to additional details of the pricing plan, and the hyperlink is labeled Get Service Plan Prices, which the FTC said that was an adequate disclosure because it indicated specifically that we're going to give you more information about the pricing as opposed to something like see details. And then finally, here's one coming sort of from tweets. This was an example of a tweet from a celebrity for presumably a fictitious dietary supplement, but there are two disclosures that would have been required here. One is the disclosure, remembering my first point, that she was a paid endorser, and the second is a disclosure, since she said she lost 30 pounds, of what the typical weight loss would be because of the space limitations of a tweet. Here, the disclosures presumably would have been made by linking to a tiny URL, which is the bit LYF56, which is a mechanism a lot of advertisers use. They will go to a tiny URL, and then the disclosures would appear there. And again, the FTC used this as an example of inadequate disclosure. Both the typicality disclaimer and the fact that she was a paid endorser in the FTC's mind would have had to be in this tweet, which obviously makes it difficult given the limited number of characters you have. The fourth thing I want to talk about, which I think is a high risk to marketers in the digital space, is the use of affiliates. And the FTC has brought many cases in the last several years and continues to do so relating to affiliate marketing. And, of course, the challenge for marketers always is that you don't always know what your affiliates are doing, and it's very difficult to control or monitor. And what's become clear from these cases is that the FTC's view is if a marketer is going to use affiliates or an affiliate network, then the FTC has certain expectations about what kind of monitoring and controls the advertiser should be putting in place. And again, a lot of this comes from the consent orders that have been issued, but the FTC expects that marketers know the identity of the affiliates, that if a network will not reveal the identity of their affiliates, the FTC's view is you shouldn't do business with that network. And they do expect the advertisers to have in place, and this may be, facilitated through the network, but to have procedures in place to monitor and to then take appropriate action, including termination. If you determine that there are non-compliant affiliates, they would expect advertisers to monitor complaints and chargebacks on an individual affiliate level. So in many of the cases, what the FTC will be looking at is what are the policies and procedures that the advertiser had in place? Did it include monitoring? Did it include looking at chargebacks and complaint levels? And where instances of noncompliance have been found, the FTC will also look at what did you do? Did you cancel the order? Did you offer refunds, particularly where the noncompliance was material? And so I think that the point I want to make here is if you're going to be using affiliates, you should have a compliance program, a compliance and monitoring program in place that at a minimum has these elements in it, because that's the first thing the FTC would want to see in the event of an investigation. And the last thing I want to talk about is native advertising. And I can't see everyone, so I don't know how many of you on the phone even know what native advertising is. It takes many shapes or forms, but just in general in terms of how we describe it, let me show you how one expert characterized it.
It's generally agreed upon in journalism that there should be a wall separating the editorial and the business side of news. It's sometimes referred to as the separation of church and state, although I like to think of news and advertising as the separation of guacamole and Twizzlers. Separately, they're good, but if you mix them together, somehow you make both of them really gross.
So this has become native advertising should not be new to us. In fact, at one point, infomercials were considered to be a form of native advertising as well. And the issue really here is some form of advertising that's designed to look and feel like editorial content. And so consumers can't always discern the fact that it is advertising as opposed to editorial. As I said, the issue really isn't a new one. I mean, the FTC has addressed this previously with advertorials. It's the same issue that the FTC had early on with infomercials, which is what led to the requirement that we have disclosures that this is a paid announcement. It's presented itself in the form of fake websites, which the FTC has already brought a number of enforcement actions, including one recently just this past week. But it's taking other more subtle forms, and I think we've begun to see some of our clients using these techniques, and I'll show you just a couple of the ones that are a little bit more subtle. It could be something like an in-feed content, so this is something that would appear in a consumer's Facebook feed. So it looks like it may just be about a foodie story, but in fact it's an advertisement for organic foods. Again, there's another one, looks like it's coming from the Today Show, just about articles, but in fact when you click on that, it goes to advertisements from these food manufacturers. Another format of native advertising is what we call custom content, and this is one where, and I know a lot of our ERA members are doing this, where you basically will have stories written that may talk about a medical condition, or it may talk about the traumas of being overweight, or other sort of human interest type stories that don't specifically promote a product, but certainly lead you to want to buy a product as a possible solution. Another one is what's called recommended content, and these are sort of media buys that happen on publishing sites. So, for example, if you look to the left here, these are all on the publisher site. It will say recommended for you. And every one of these actually, when you click on it, relates to some kind of an advertisement. So the one I highlighted here is exercises you must do if you want to lose weight. You may think, looking at this, that this is another story, about exercises, but in fact, when the consumer clicks on it, it will take it to some sort of a exercise ad. And this next one is similar to that. You might also like, again, appears on the publisher's site, and you see there, superfoods to stop aging. So you might think, again, that's an article that Time is recommending about superfoods, but in fact, when you click on that, it's an advertisement for some type of superfood. And so what's happened here is the FTC held a workshop about native advertising, really to start the conversation and, put out there that, again, if something looks like editorial or native content, but in fact it is an advertisement, then that will be considered misleading and a violation of Section 5. And so there needs to be some kind of disclosure about the fact that this is sponsored content or the fact that it's an advertisement. But the FTC hasn't come out yet with guidance. What has happened, however, is that the National Advertising Division of the Better Business Bureau, which is the same organization that IRSP is a member of, they've actually taken a very, very active role in this area. And just to give you an example, they brought a case against Taboola, which Taboola basically has widgets that, in the examples I showed you, for example, you might also like or recommended for you. They provide those widgets that you can put on the publisher's site with the particular sponsored content that you want the consumer to link to. NAD recently brought an action against American Express, which used Taboola to do, sort of one of these native ads where it said recommended for you, and there was it was going to link to a story by American Express for its open forum product, which is a small business product. There was actually a disclosure of the fact that this was sponsored content or promoted content. The disclosure was in the upper right-hand corner of the little box. It was in small type, and it also said sponsored by Open. Basically, what the NAD said is that disclosure was insufficient, that consumers, they actually objected to the placement and said consumers wouldn't see something on the upper right-hand side. They might only see it on the left-hand side, that it should have been larger, and that actually just even saying sponsored by Open, which was the name of the product, wasn't sufficient, but that the name of the company had to be disclosed. In other words, to disclose the fact that if you clicked on this, you would be taken to an ad by American Express. So the point I want to make here is the FTC, has not been as aggressive in this area yet, but the NAD has kind of been the watchdog in this area and is taking some very aggressive positions regarding the type and the prominence of disclosure that needs to be made. But we expect, again, the FTC's gone after the more egregious ones like the fake websites, but we certainly expect in the coming months that the FTC will weigh in on some of these more subtle uses of native advertising. So with that, those are my 5 for you, and I'm happy to take questions on anything I've covered. Hello?
I haven't muted anybody. Is anybody having a problem with the phone connection? Hello?
This is Eileen. I'm not having trouble. It was a wonderful presentation.
Agree. This is Joe from Thane. Yeah, I agree.
I actually didn't click into the visual initially, so Linda, I followed you, from the audio relative to disclosure of negative option continuity on the landing page. I'm wondering if your presentation slides are going to be sent after the fact? I could just look at what you were referring to.
Yeah, I didn't provide any examples in the deck, but basically, to put a little more meat around the bones, what the FTC is looking for in a negative option is they're looking for a checkbox. And sort of immediately adjacent to that checkbox would be language relating exclusively to the negative option. So it might be something like, by checking the box, I understand that, let's say it's a free trial
Mm-hmm.
after 30 days. Unless I cancel, I'll be charged, X dollars a month, or I'll continue to receive shipments every 30 days at X dollars a shipment. And they're looking for that very distinct disclosure adjacent to a checkbox, or, if you're not going to use a checkbox.
Is there an example of somebody who's using that today that I could just look at? Because I don't, Linda, this is, at Vintage, I don't think that's the norm right now in DR on a checkout page.
That's why I'm raising it. Because that's why I say it's kind of the gloss. I think you're seeing. I think you're seeing it a little bit more now, as the FTC has had more enforcement, or at least if you're not seeing the checkbox, you're seeing a very distinct disclosure of those negative option terms. And I think I think Google has also, it's my understanding that they have required a checkbox as well.
I was just going to look at.
But if you look at the FTC's consent decrees in a case they brought against Green Millionaire, a case they recently brought against One Technologies, you'll see that language in the negative option section of the consent orders. Now, again, those are consent orders, and that means those companies have been subject to enforcement action. But the message, I think, and what we've, seen from the FTC, we've been involved in 3 of the 4 ROSCA cases, is that where the language simply says, I agree to be billed, I agree to the terms and conditions, or something like that, or I agree to be billed, that my credit card can be charged, on the terms and conditions specified with a hyperlink.
Yeah.
They are definitely not going to accept that anymore.
Just as an example, I pulled up the proactive site, which we know is a continuity, and the terms are, there's no checkbox with the terms. They fully disclose the downstream continuity, and they collect billing information, payment information, and then there's a checkbox that says, by checking this box, you are electronically signing your order, agreeing to the terms above and to our general terms and conditions, and authorizing us to charge the payments to the credit card you have provided. That doesn't sound like it meets your criteria.
Well, I think in terms of, I think without being subject to an order, at least there, I'm not looking at the page, but it sounds like the terms and conditions are above the billing terms. So you're not accessing it immediately, you're not accessing it solely via a hyperlink. Yeah. So you do have the checkbox, and you do have the full disclosure on that page. Uh-huh. That would probably be sufficient.
Okay. Thank you so much.
What I'm referring to is if you didn't have those offer terms there, uh-huh, and you simply had a checkbox, or something that said, even worse, by clicking the submit button, I agree to the terms and conditions, and everything was via a hyperlink.
Got it. Because merchant banks have been tougher on this point, and they, as well, probably for similar reasons. So thank you again for your clarity.
This is Jennifer Sharp from Joyous. I'm wondering if you could talk a little bit more about the requirements for disclosing native advertising. And, just looking at sort of Outbrain, Taboola, and some other content, it seems as if the sponsored by piece is generally pretty subtle. It's in a lighter font, and it's sort of varied in terms of treatment for how people do disclose. Just wondering if you could share a little bit more about sort of what's required today and where you think that's going.
So where I think it's going is that I think the sponsored by is in terms of how you disclose it is fine. As I said, the NAD, and that's why I brought up the case, I think they got ridiculously granular in saying, well, it's got to be on the upper right, it can't be on the upper left. I wouldn't, necessarily go so far. I think the most important things to me would be it's in a size that's readable, and it's in a font that's contrasting with the background so that you can see it. And I think it's, and you have to know who it's sponsored by. I don't think it's just enough to say sponsored content. So I would say.
And in some cases I've noticed they just, like on the website, they'll just, even within Outbrain, they just feature the other company's name without saying specifically sponsored by.
Right. I actually don't. There have been a lot of discussions about that. I actually don't think that's enough. I don't think either FTC or NAD would think that just having the advertiser's name there without expressly indicating, that it's sponsored by or paid for or, promoted by would be sufficient.
Okay, and can we? Is there a place that we can go to kind of check on the latest in terms of guidelines?
I think the best articulation right now, probably if you have access to the NAD case studies, would be to read the Taboola. There are 2 Taboola cases. If you can, I can send them to you in a PDF.
Great. Thanks very much. Great presentation.
Thanks.
Hi, Linda. This is Sonia from Williams. I just have a question for you regarding how the FTC works. I'm wondering what the triggers are that causes FTC to really take a closer look at a specific website, because there's thousands and thousands of websites out there. So I'm wondering how they figure that out, and also, these guidelines, I'm sure it's a work in progress that's constantly changing. So what are they doing to kind of get that information out there?
So it's a great question. In terms of how they work, in all honesty, a lot of it is Russian roulette. But I think there are 2 key activators. One is it's a very consumer complaint-driven agency. So they don't have unlimited resources, and so their first priority is really to look at companies where they received a significant number of complaints. I will tell you that in our industry, and they've admitted this, they read the reports and they look at who the top basically what are the top shows, and will then go to the websites as well because they know there's money there. And then sometimes they will just look for something where they think it's a sexy issue. That's more often the case with some of the brand marketers that get hit. Like they just went after Sony for this blogger campaign. And I think the reason they went after Sony was because it was a big name, not because the conduct was that egregious. So I think it's those 3 factors. But I think for our industry, it's mostly complaints and, unfortunately, success. When they see that a show is spending a lot of money on media, they will almost inevitably take a look at it.
Okay. And are they being proactive in making sure that we know what the guidelines are?
So in terms of how are they articulating the guidelines? So they're really using, and that's why I based a lot of what I was saying today on consent orders. I mean, they don't historically issue new guidelines very often. They will review their guidelines, every 5 to 10 years, or certainly when there's a big change in media, which is, what happened with the .com disclosures and then the testimonial guides because of social media. But in general, what they do today is they really use the consent decrees as a way of providing guidance to the industry on what they think is acceptable.
Okay. All right. Thank you, Lisa. I really enjoyed your presentation.
Thank you.
Linda, sorry about that.
Anybody else?
Hi, Linda. This is Kiara from Oakland Marketing. Thank you for a great presentation.
How are you?
Good, thank you. So in one of your slides, I think I remember seeing you say that pricing and cost can't be in a hyperlink.
Right.
Is that correct? Okay. So then
unless it's, for the most part, I mean, there was one example of the home protection system where there was a very, a lot of other fees and costs and things like that, if it's a very complex pricing plan, you could possibly do with a hyperlink. But in general, the FTC has said that safety information and basic costs and prices, can't be made via a hyperlink. And now you can layer, onto that the recent All-Star case, which, I think also says shipping and processing, needs to be disclosed up front as well.
A couple of slides later, you showed an example of, I think the company was Eyes on Me, with them showing a $99 price plus a hyperlink for further cost explanation.
Right. And because, again, that's an example of a really sort of detailed product where there are, other pricing issues may depend on what options you choose, what features you choose. So the basic plan was $99.99, and if there were other costs associated with the basic plan, those couldn't be done through a hyperlink. But there are lots of different, suites of services you could choose. And so the details on all of the plans and what they would entail if you had other add-ons and things like that were able to be disclosed via a hyperlink, but the basic plan price could not.
Okay. Got it. Thank you.
Does anybody else have any questions? All right. Well, thank you very much, Linda, for taking the time out to
thanks, everybody, for joining.
Presentation. Hopefully it will be up on the blog within the next week or so that we can send that around for everyone who couldn't see it. And we have not set a date for the next one yet, so just be looking out in your inbox for the next presentation. And thank you, Linda.
My pleasure. Have a good day. Have a good weekend, everyone.
You too. Bye-bye.
Thank you.